criminal law is constantly evolving. It's right there in black and white, right? It's constantly evolving. And as we've discussed, what may have been a perfectly useful law 40 years ago doesn't apply now. The times change, people's opinions change, our moral compass changes, social aspects change, and so the laws need to change too. And new crimes have to, new laws have to be created to combat new crimes. For example, computer and internet crimes. In the 80s and early 90s, we wouldn't have cybersecurity. We wouldn't have, these hacking and phishing and all of these identity theft involved. We've had identity theft, but identity theft involving, the internet and cyber crimes. That's very new law. So other aspects of criminal law, we've kind of already talked about this. As the times change, we can add new laws, we can get rid of laws that no longer serve a purpose. Let's talk about some new laws that are fairly, when I say new, not last week, these are within the last couple decades. Physician-assisted suicide, where a doctor can help a patient who is going to die, not somebody who comes in and says, hey, I want to commit suicide and I want you to help me. No, they have to be dying. New York's highest court said, no, that's illegal. We do not have that. That's a crime here in New York. Not every state has that, but there is no such thing as physician-assisted suicide in the state of New York. Stalking is a fairly new crime, early 90s, and it came about as a result. California was the first state to pass a stalking statute. New York has several versions of stalking. It came on the heels of a celebrity who was murdered. The whole Rebecca Schaeffer, she had this crazy fan that was sending her letters, showing up at her doorstep, and one of those times he pulled a gun out and shot her. And there was no laws protecting against that. So this was to combat and hopefully stop that, an assault or a murder, stop the type of contact. And stalking involves doing some course of conduct that puts the other person in fear. That's the general definition, following them around, sending them letters, sending them texts, those kinds of things. Community notification laws are fairly new. SORA, the Sex Offender Registration Act, where a person who's convicted of a sex offense has to register. Let's put the community on notice that there's a sex offender in that particular community. The laws regarding rape have reformed and evolved since the 70s, and they're still changing. Back pre-reform on rape laws, which takes us to the 60s and earlier, a husband could rape his wife. The victim of rape was only a woman. Certain sex acts were punishable by a crime despite the fact that two adults consented into the activity. All of those things have changed. Controlling technology, I just talked about that one. Protecting the environment. Those are fairly new laws. We're on the cusps of, legalizing marijuana. Some states do, some states don't. And of course, we've had lots of laws come since 9/11, responding to terrorism. The most common one that we are all aware of, the U.S. Patriot Act. We also have the U.S. Freedom Act. We'll talk about that in a little bit. So, crimes evolve. And when needed, new crimes come in. Old crimes change. They go through reform. So our U.S. Patriot Act, the feds, and the gist, this is after 9/11, U.S. Patriot Act is passed, and it allowed basically for wiretapping, the government's ability to track individuals, and allow the government to collect business records without warrants or somebody else's knowledge. The U.S. Freedom Act actually restored portions of the U.S. Patriot Act that expired. So the you know the concept is, you got to balance these things. Like, isn't that an invasion of privacy that allows the feds to monitor us? Remember Edward Snowden? If you don't know who that is, Google him. He kind of blew it out of the water a little bit of the government spying on us, like we didn't know that already. But you got to balance between our rights or our liberties to this, threat of safety in our country. So the U.S. Patriot Act and the U.S. Freedom Act. Constitutional criminal procedure. We are going to delve into a couple of these rights in a lot more detail when we're talking about law enforcement, because that's where most of the issues of criminal procedure come up. But in the general sense, these are the rules and regulations that govern the pretrial process and the behavior of the criminal justice folks. You were talking about the law enforcement, we're talking about the prosecutor and the courts and corrections. All of those folks can violate the Constitution. And the first 10 amendments of the U.S. Constitution is the Bill of Rights. We know that from hopefully a history class or a government class from high school. And that's where they come from, okay? So the purpose of these amendments is to prevent the government from stomping on our rights, okay? This doesn't mean individual people. I can't violate your constitutional right. You can't violate my constitutional right. This is the government violating individuals' rights. So let's kind of talk about these a little bit. A little snapshot, and then we'll go into some more detail on some of them a little later. Fourth Amendment. We will address this in painstakingly detail when we're talking about law enforcement and their investigation. Search and seizure. When can the government or law enforcement conduct a search? It is a very gray area. There could probably be an entire course just on this amendment alone, and there's tons of exceptions to the rule. But you have to know it exists. It's in the Fourth Amendment. And generally, before law enforcement, any level, law enforcement, local, state, feds, can search and seize private property, they must obtain a warrant. Property consists of home, their personal selves, cars, sheds, warehouse, all sorts of possibilities of what is our property, what they can't search. As search warrant, that's an order from a judge authorizing the search and seizure. And the warrant has to be specific. It can't just be, sure, go have at it, go search this property. And there must be probable cause, a little buzzword, probable cause. It's not, oh, I had a hunch that there was illegal activity going on inside that house. Nope, their police investigation has to reveal that property contains the illegal item that they're looking for, whether that's documents or guns or drugs or fake credit cards, whatever that may be. They need to have probable cause. So that's the gist of the Fourth Amendment. We'll talk about it, like I said, in more detail. And I should say, I'm going to tell you what happens at the end. If the police do not have any one of those exceptions to the rules, like consent, right? If you get somebody's consent to search, you're good to go. If something is laying right there in plain sight, good to go. If they're in an emergency situation, let's say, word has it, this particular house has a bomb and it's going to explode, like, they can go in without a warrant to ensure public safety. And if they don't meet one of those exceptions, and they don't have probable cause. Everything that was seized can't be used as evidence. They call that the exclusionary rule. Fruit of the poisonous tree. Everything that extends from that bad search is tossed out. It's gone. So that is our Fourth Amendment in a general sense. We'll talk more about it. We're also going to talk more about the Fifth Amendment. Self-incrimination. We'll talk about due process in my next slide. Self-incrimination. You have the right to remain silent. Anything you say can and will be used against you in the court of law. So, this gives a defendant or an offender the ability to say, I'm not talking to you. And I have that right to do so under the Constitution. This is why the district attorney or the prosecutor has to prove a case beyond a reasonable doubt, and the defendant doesn't have to prove anything, because they don't have to take the stand. They can remain silent. This also involves interrogation, right? Interrogation tactics. We'll talk about that under law enforcement. The Sixth Amendment has our right to a public trial and our right to a jury. Meaning because it's the government, the public can come and watch, and they're entitled. And I should say this allows the public too, not just a defendant. This allows the public their right. So if you show up at a criminal trial and you want to watch it and the judge says you can't come in, that's a violation of your constitutional Sixth Amendment right to watch an open public trial. The defendant's right to have a jury, also under the Sixth Amendment, is the right to an attorney. You have the right to an attorney. And the defendant has the right to face their accusers or confront witnesses. So the people in the prosecution put on these witnesses that say the defendant did this crime. The defendant is entitled to cross-examine and face them. If the people don't call one of those witnesses, the case could be subject to dismissal. The Eighth Amendment, protection against cruel and unusual punishment. So if you steal a television from the mall and you're sentenced to death, that would be cruel and unusual punishment. The crime doesn't match the punishment. We'll talk a little bit more about that one. And the 14th Amendment applies to states. Basically, what happened here, there's a lot of state arguments early on saying, hey, your federal constitution doesn't apply to us. We got our own thing going on. And the 14th Amendment was passed that said the protections set forth in the Bill of Rights apply to all the states. So this is where we talk about things like due process and equal protection. Due process. It's the Fifth Amendment for the feds, and it's the 14th Amendment for states and any other government entities. So let's talk about due process. Gotta find my due process sheet so I don't miss a... All right, back to due process. And I'm also going to talk about equal protection. They're under the same clause. And where are most constitutional protections afforded? Bill of Rights. First 10 amendments, they apply to the states, they apply to local governments, they apply to everybody. After the Civil War, the 14th Amendment was added, and that included due process and the equal protection clauses, and what it did was it afforded more protections and encompassed the protections afforded for everybody. So what is due process? What do we mean by due process? The due process clause, it says no person shall be deprived of life, that's capital punishment, liberty, incarcerate you, or property, take your property or require you to forfeit your property without due process of law. So what does that mean? Due process, fair treatment through the normal judicial system. That's what you're entitled to, fair treatment. The police cannot come and get you at your house and then stick you in jail where you sit for 3 months. That's not how due process works. It protects individuals from unreasonable loss of their fundamental rights. These are usually exercised as some form of defense. A common argument when a defendant loses their criminal trial and they appeal, one of their common arguments is, I was denied due process because I did not have effective assistance of counsel. So I was deprived my right of due process. That's a common one. The prosecutor's misconduct. The prosecutor withheld evidence that they're not supposed to withhold under the law, and that violated my due process rights. So, fair treatment through normal judicial system. That's what we're entitled to. All right. Where does it apply to? Well, actually, let me just jump in and talk about equal protection real quick since I mentioned it. The 14th Amendment also protects us, gives us equal protection for all, okay? And it says, nor shall any state deny any person within its jurisdiction the equal protection of laws. And this applies to the states as well. It applies to the federal government under the Fifth Amendment. And the purpose of that is to prevent the states from enacting criminal laws that discriminate in an unreasonable and unjustifiable manner. These laws target, right, a class of person for special treatment: race, sex, national origin, disability. A perfect example would be a law that is passed that says it's illegal for women to wear a bathing suit in public. That would be deemed unconstitutional because you're targeting specifically a woman. All right. Due process. So it includes the following. These are a lot of the following attacks that are common: freedom from illegal searches and interrogation. If any of those happen, the argument is my right of due process was violated. Prompt because of the legal search and seizure. Prompt notice of the charges and a formal hearing. You have to be notified of charges right away. And our New York State statute says like within 24 hours of it being charged. The right to counsel, right? If you're denied counsel, let's say someone's being questioned by the police and they say, I have a constitutional right to an attorney. I want to talk to an attorney. And the police say, you don't need an attorney, and continue on. That is a violation of due process. They're entitled to their opportunity to respond. The decision has to be made relative to the evidence, the substantial evidence. That's one of the challenges too. Sometimes there's a jury verdict and the evidence isn't supportive. It's not an appellate court saying, yeah, they got it completely wrong. They'll review the evidence itself to make sure it fits, that the decision that the jury makes is a lawful one. They won't change it. They'll say, oh yeah, there was enough for them to decide this and we're not going to touch it. Any written statements entitled to appellate review of any of the processes. So that's what due process lays out in its general form. And the Constitution, in interpreting the Constitution in the criminal sense, it's the U.S. Supreme Court who has the final say. Certainly it's not fixed. It does reflect what society deems fair and just in a particular time and place. And the standard is that scale, the balancing scale. What's the state's interest over the loss of rights suffered by the individual? When there's a challenge to due process or somebody claiming a violation of one of their constitutional rights, the court engages in a weighing scale. Any court that's faced with that question. It could be New York State's highest court interpreting the New York State Constitution. But in this example, I'm using the United States Supreme Court. They will weigh that right against the state's interest. And that concludes our overview of criminal law. we're going to speak in more detail regarding some of these constitutional rights when we talk about law enforcement and the court system, because that's how they're going to get flushed out. You'll see where they flush out relative to our discussion.